everybody again. Thanks for being here. Today I want to talk a little bit more about the presumption, but I want to tie in the exhaustion of administrative remedies. This is the doctrine. It's called the Doctrine of Exhaustion of Administrative Remedies, and it's in the Black's Law Dictionary under exhaustion of administrative remedies. And it starts out and says that the doctrine requires that where an administrative remedy is provided by statute, relief must first be sought by exhausting such remedies before the courts will act. Okay, so what we're finding here is this is the doctrine, this is the law, the rule, that you go to your adversary before you go to court. So you have to settle this with the adversary. And when you're stopped or approached by an agent, then you're in court right there, and you have to exhaust the remedy of finding out exactly what the charges really are. And the reason why I say that is because we just learned about the presumption, the rule of presumption, so we don't know exactly what the charges are because the agencies are acting under what's called a presumption. So once the officer stops us and he's operating under the presumption that we're driving, well, we have to raise this issue before it gets to the court. Otherwise, they're going to go by this fact, presumptive fact, as if it's the truth now because we didn't object. And where we object is at the administrative remedies before we get to the court. Now, under this doctrine, a petition for a habeas corpus by a state, the doctrine requires the party to use all available agency administrative procedures before resorting to the court for relief, and requires that a party not only initially raise the issue in the administrative forum, but requires the party to proceed through the entire proceeding to a final decision on the merits of the entire controversy. See, so this means that when you start to exhaust this remedy, you have to take it all the way, because what will happen is you might raise it at the hearing or at the initial confrontation with an agent, but then if you don't conclude it, at the very end, he may flip right back over to his remedy, which is his presumption. So we have to get it all the way through and make him produce the evidence that forms or is the bolster or the basis of his complaint. Okay, and that evidence is going to be that you were driving. The evidence that he has to violate your security and show your papers. See, because we have to remember when you first get pulled over and these agents approach us, if they want to talk to us, they're going to have a cause to act. And that cause is either civil or criminal. If it's civil, then it's like a citizen's arrest. If it's criminal, then he's going to need a warrant. And that'll be the basis of his presumption. Now, if he doesn't have a warrant, then the basis of his presumption is that he doesn't need a warrant because you're doing an activity that he can regulate, and that would be driving. Okay, so if you're presumed to be driving, he's presumed to have authority. But what if you rebut that presumption? Okay, the form of rebutting it would be in the nature of exhausting your administrative remedy. Oh, well, wait a minute, you are presuming that I'm driving, you're presuming you don't need a warrant, but I'm going to have to rebut those presumptions, and I'm going to require you to produce the evidence now. Because you're operating under presumption, not under fact. See, and if you don't meet that presumption right there, then they're going to presume it's a fact, because you didn't raise the issue. And if you proceed to the next step, then it becomes a fact that you were driving. And he doesn't have to prove it. So this says the presumption, the doctrine of exhaustion of administrative remedies is the opportunity to rebut the presumption. This is where the presumption is rebutted. Because if you don't rebut it by the end of that administrative hearing, then you've agreed. And it's become a final conclusion. And this is what we have to understand. And that's why when you finally get to the court, you're already guilty. And that is shown to you by them saying, well, we're presuming you're innocent. When they presume you're innocent, that means you're guilty. So that's how they're operating, by the presumption under the exhaustion remedy. Now, if you meet that presumption, the burden of producing the evidence shift over to them, the other side, and now they have to produce it. Okay, so we need to understand the burden of proof and the burden of producing evidence and the rules of evidence, and this is how these trials operate. Basically by these rules of evidence and the rules of court, the rules of procedure, and we need to understand that so that we can then take the proper action. So we need to learn how to rebut these presumptions, when to rebut the presumptions, where to rebut these presumptions. And that's the next phase, is this action. What actions can we take? And by actions, I mean by speaking up, by filing paperwork that's going to cause the court to shift, or to even cause the court to make a determination if that court has authority to hear the case yet. Because when you go to agree with your adversary in an administrative hearing, that should stop the case from going to the next step. Because these courts don't have authority to hear a criminal case unless there's an actual crime. And they're not set up to hear a civil case unless it's brought by another individual. So we begin to see that an administrative hearing and action, there's really no cause of action, because they're operating under a presumption that they don't need a warrant. And so when we go into these courts, we're giving them authority to proceed because we don't object, and once we don't object in their court, they can do whatever they want. There is no law that they're required to follow, because the law that they're following is the presumption law. And operating under the doctrine of exhaustion of administrative remedies, you had your opportunity to rebut the presumption. You failed to do so. Now you agree. So why are you arguing here in the court? Okay, so this is why people are losing right and left, because they're going into the court. Our paperwork and our goal is, what we want to do is to get to the court and tell the court that we're not ready to proceed, that they don't have the authority to proceed, and that they're not set up properly. And the way we're going to do that is by bringing in these agents and having them testify to these facts that they're not proceeding properly because we rebutted the presumption and they failed to meet that presumption. Okay, and so these are the words and understandings and angles that we have to grasp so that we can take the next step of taking the action, putting in the paperwork, meeting the presumption, and stopping the case cold right there and having them dismiss us on the grounds that they don't have authority to proceed because there's no cause of action stated in the plaintiff. Okay, and so next time we'll start working on the paperwork and the different items and motions or papers, things that we need to put in so that we can actually take action and do something, because that's what's required in order to maintain our liberties and our freedom. So thanks for being here, and I'll talk to you next time.